Good afternoon, all of you. It's a post-lunch session, so bear with me. You can all also have some coffee while you listen to all of us. But I'm so happy to be back here again for BW 30 Under 30, exactly after a year's time. And I have a very, very interesting panel today. Of course, Seema Jhingan, she's founder partner of LexCounsel. Kanika Sachdeva, she's regional counsel with Stryker. Vaibhav Kakkar is senior partner with Saraf and Partners, looks after M&A. Pranav Chawla is legal counsel for Ofbusiness. He takes care of M&A. This company is a unicorn, which of course we all know is a valuation of over $1 billion. Alankrit Bajpai is legal counsel with Whiteland Corporation. And just before we started this panel, I was huddled with them for a meeting, just discussing what all they do. And they're a really interesting set of people, and all of you are going to enjoy what they share today. I have a tight schedule to adhere to, so without wasting much time, I'll just start with the round of opening comments. The topic is what promoter-driven businesses need to know. We all know in India that it's very different working for a multinational from working to a promoter-driven business, from working to a startup. You know, in a sense, the attitudes towards the running the business, they vary very, very greatly between these three kinds of businesses. Each of them is rewarding, but it is upon a person what choice to make. I'll start with Seema Jhingan, founder partner LexCounsel, for her opening comment. Over to you, Seema.
Good afternoon, everyone. So let's start with what PDCs are. I mean, I call them PDCs for sake of brevity. It's the promoter-driven companies. They basically are controlled and managed and completely under the hands of the family or the promoter himself. Now, first of all, let's understand their contribution to the Indian growth story. They have been the key contributor to the Indian growth, Indian development in terms of economic development in the last 1 decade. In their counterparts, the MNCs have been failing, there have been closures, but the PDCs have led from the front and done phenomenal work. I mean, there's a recent report which said that PDCs have, right now, 75% of the stock exchange market capitalizations are PDCs. So that's a phenomenal growth factor. Their profits, their share valuations are far ahead of their counterpart MNCs. So they have done a lot of contribution to the Indian economic growth story as we are today. But they are not also free from, let's say, non-compliances. Sometimes they are intentional non-compliances, the fraud, the corruption. And as per a MCA report, which talks about the initial IBC cases, the largest reason, in fact, 1/3 plus reason for the IBC winding up and closures and takeovers were because of the fraudulent conduct and siphoning of funds by the promoters. So what is it that drives them to create a situation where their own company gets wound up because of the greed and the sort of self-interest conflict which we have? The primary reason now why are we talking the changes happening in the PDCs and why this topic is so relevant, that this is not going to last anymore. The PDCs are now, it's a globalization world. We are exposed to a lot of global best practices. The consumers do not want to interact with or buy, purchase goods from companies which are not transparent or not accountable. The social media does so much of hyping in terms of any errors or fraudulent activities. Adani is one of the case in point. And then there is also pressures by shareholders to bring transparency and accountability. And there are several other factors. Now let's look at a situation. What is it that leads to where we are in terms of fraud? I mean, the largest 66% of the story in a PDC run companies is they are marred by corruption. Then there is fraud, and then there is accounting inaccuracy. Why is it something which is so significantly attributed to PDCs and not MNCs? There are cases of fraud in MNCs as well, but why it is more attributed to PDCs is, and I think the largest reason, the biggest reason, and I'm talking about all purely from my own experiences in dealing and advising PDCs, is that one biggest reason is the centralization of power. The promoter and his family has so much control and so much control in terms of taking decisions and self-interest plays a larger factor. And it's not always self-interest in terms of corruption and fraud. There is a story that they want to be number one. They want to grow very fast. The acquisitions are, there was one large PDCs that we interacted and we worked with them for last I think more than a decade. Their growth story was phenomenal. Everybody would have known their name. Their motto was acquire, acquire, acquire. As many as acquisitions that they can do, that is the numbers that they will release on the stock market. That is the way their stock valuations will go up. So it's not always the reason that they have self-interest. It is always they want to do well. They want to, every quarter, they want to show numbers, deliverables, and actions. The expansions, the acquisitions, and the other developments that they have done in company. So that's one of the biggest reasons, and that is something, the predominant reasons that why the corruption and the fraud happens most, because the compliances, when the focus is only growth and growth, the compliances are sidestepped. That's number one. And I'm talking about far extensive experiences with many, many PDCs. When your focus is only acquisitions and growth, compliances are ineffective and they're waste of time.
That's a very interesting comment you made, that when the focus is growth, compliances become a casualty. I'll take that on, and I'll go to Alankrit Bajpai from Whiteland Corporation for his opening comment.
Hi, it's been a long time since I've been advising the promoter-driven businesses. I've been associated with the billion-dollar companies who are into real estate, primarily in Gurugram. So while we acquire the land, there are a lot of, I totally agree with Seema on what she said, that they are so focus-oriented on the growth they want to do. They are so focus-oriented that they forget about the legal things which they need to adhere, the legal things which they need to take care of, in order to give the best to all of us. So a house, when we buy a house, it's a dream for us, right? So there are a lot of compliances which you need to do. There are environmental compliances, there are fire compliances. But what I've seen is the promoters, they don't care about what they need to do. They just need to construct the project and sell it as soon as possible. And about the problems being faced by the promoter-driven businesses, I feel micromanagement is something which is the basic concern, and which is the reason that promoter-driven businesses are facing a lot of problems too. They are at a place where they have had a lot of growth, but they're stagnant at this point of time, because they want to manage it all by themselves, and they don't wish to decentralize. And with the people, I think there is an Indian mindset where we think that, if a family is driving the business, they will do good for the business. They will take care of the business as it's running their houses. But I feel that this needs to change, and this needs to change completely, and we should decentralize everything. There should be powers given to the board of directors. There should be independent directors which should be on the board, which should advise from the expertise. I know when I run a business, even if I'm educated, I'm not educated, there are a lot of things we learn while we are growing a business. But still, there are some things which I need an advisory on, and the legal department has always been a keen structure to such organizations. So I feel that promoter-driven businesses, though rightly ma'am said that 75% of the market capitalization is done by them, but I think it's high time. There are some things which needs to be changed, and being the legal people, being the legal advisors for these companies, I think we should advise them about how the compliances, how certainly they should, what things they should do in order to grow the business better.
Point well taken. Thank you so much, Alankrit. I'll go to Vaibhav. Vaibhav, your opening comment.
Thanks, Tarun. I think this is working. Thanks, Tarun. Good afternoon, everyone. Look, I think one has to take a bit of a look at the overall macro picture, Tarun. If the last 20, 30-year growth story has to be seen, of course, Indian promoters and Indian entrepreneurs have to be given all the credit because they've been at the forefront of it. And as Seema very rightly pointed out, a lot of growth is being driven by Indian businesses, Indian entrepreneurs at a time when most foreign banks are exiting this country. So look, you have to give credit where it's due. But they needed to be a mindset shift. A lot of times promoters would actually look at companies as their own family-owned enterprises, as their own personal asset. And they would deal with those organizations as if it's their personal fiefdom. So that needed to change. That mindset shift needed to happen. That if you are raising investor money, you do owe a fiduciary responsibility how that investor money is spent. And so you have seen many instances now, even in the unlisted space, where these so-called unicorns, when they've raised a lot of capital and the promoters or the founders have not acted appropriately, they've had to pay a heavy price, and they continue to pay a heavy price. And investors are getting questioned that did they overlook? Did they go very easy on the founders and their vision without scrutinizing them? So there is that degree of fiduciary responsibility which has to be there on the promoter when he's raising public money. And that public money could be private equity investment, that could be in the form of venture capital investment, or it could be in the listed space. And so that mindset shift needed to happen, and which has happened over the last 20, 30 years. Shareholder activism is at an all-time high. But in the same breath, what's also happened, Tarun, is that, as typically things happen where pendulum swings one way on the extreme left, then it has now swung on the other end of the spectrum as well. And so now we have a SEBI consultation paper that has come out recently, where practically majority and promoter voting is becoming irrelevant. Almost 9/10 of all corporate transactions as per law going forward will all require majority or minority approval, which means that your public shareholders will pretty much rule and run the roost. And there have been so many times we've seen even minority shareholders taking the company and businesses as a hostage. What needs to happen is that mindset needs to change, that promoters are chore. I'm saying it colloquially, but there is this mindset with the regulators ki sare promoter chore hain. Now, if you try and if you do rule making on the premise that everybody is out there to abuse the system, you will end up creating extreme frameworks for yourself. And that I fear is what is happening. You do have instances of banks, private sector banks buckling down. You do have instances of large listed companies buckling down because of promoters siphoned off. But I wonder if the problem is with the law or with the enforcement. And that needs to be tackled, but rule making cannot be to deal with extremes, cannot be to deal with exceptions. You have to respect promoters, you have to respect the value that they bring, and keep incrementally improving governance. It should not happen, and I want to say this out, Tarun, as part of FICCI Committee on Corporate Laws, as part of CII Committee on Corporate Laws, some of the changes that the regulators have done are so unprecedented, there are no parallels across the world. It is that higher standard that is being expected of all the good listed companies. And the errant promoters who ever want to do what they wish to do will always give those rules a go by. So I think that's a tricky part to think about.
Thanks for that interesting opening comment. I'll go across to Pranav Chawla from Ofbusiness. Pranav, you can introduce you and your business and your opening comment quickly.
Thank you so much, Tarun. So Ofbusiness is into trading of wholesale raw material. And recently we have also started doing manufacturing. So last year we became a unicorn. In 2021 we became a unicorn. And we do also have an NBFC, a financing arm. So we do the wholesale trading of industrial chemicals, construction raw material like steel, bitumen, etc. So recently, we have also started doing a lot of acquisitions. So in these acquisitions, we have also seen that, a lot of these companies are promoter driven. These are very closely held companies where promoters are the only ones who used to take care of all the business. So while we are doing an acquisition, what we do is, if the company is doing a lot of non-compliances, there is no corporate governance, then we make sure that as a condition precedent, they resolve all these things. And whereas if there is a high risk, then we just try and avoid the deal and we call off the deal. However, if the risk is low, we try that as a condition precedent before doing the infusion or before paying the money. We just try and resolve all those issues, and we make sure that the asset which we are acquiring is pretty much clean. But one thing which I have seen in all these closely held companies is that since the promoters, they have a mindset that they just want to do compliances on a need to know basis. Only limited things they'll do, which are required. So in order to just get away from the eyes of the regulators, and else वो एक word है ना कि भगवान भरोसे चल रहे हैं. So all these things happen.
Thanks
Yeah.
for your opening comment. I'll go across to Kanika Sachdeva. She is regional counsel with Stryker. Kanika, if you could just talk about yourself, the company, and your introductory comment.
Hi, good afternoon. Stryker, I'm associated with Stryker for some time now, and it's a medical technology company. I haven't really dabbled with some of the scenarios of promoter within this, private company, which is a subsidiary of foreign listed company. But definitely, in the past, we've seen scenarios where promoters and a lot of corporate scandals. We have seen a lot of corporate scandals, one which is hotly debated at this point in time. There have been certain issues which have come to the forefront. We've seen scenarios where promoters start to confuse themselves as one with the company. Now, when it comes to promoters, we need to understand, appreciate that it's a very unique Indian concept. Generally, controlling shareholder is a concept outside of jurisdiction of India, right? But technically, and by the way corporate structures are designed, what happens is promoter end up actually holding a good chunk of shareholding. And that is the reason why they tend to start over-involving themselves even with the strategic decisions or the affairs of the company. They feel they're the owners, and their duty is actually it's self-interest, as Seema mentioned. That they start prioritizing self-interest over the interest of other constituents of the company. And that is something a watch out. As Vaibhav mentioned, there has to be a huge change in the mindset of the promoters, of the legislators, because now we see that there is some sort of over legislation as well. There have been a lot of changes with respect to the Companies Act. There have been a lot of changes when it comes to the LODR, and we've seen that now we are getting into a space where we started getting a lot of resistance from the industries, because they feel that there is over interference of the legislator in the day-to-day operations of the company. Because at the end of the day, we have to appreciate promoters are the one who've really brought company to a particular stage, right? So their insights are valuable. But when their decisions tend to get diluted by, say, wherein you need special or ordinary resolution by the shareholders, every single matter goes there. It becomes difficult for companies also to run their business. So there is a fair balance that needs to be maintained between the interest of the promoters as well as what the regulatory framework is trying to achieve by ensuring that the interest of all stakeholders are equally protected. There shouldn't be really arbitrage between the sets of shareholders.
Thank you, Kanika, for sharing that perspective. I have about 12 minutes to go exactly. So what I'm going to do is take the second question and request the panelists to make their closing comment along with it very quickly. Seema, of course, what was your advice to promoter-driven companies? What has been your experience all these years? Are they receptive? Are they, they would hear you out but not comply, listen? And your closing comment also.
Yeah, so see, the promoter-driven companies are not having dirt of legal advisors and law firms and very, very competent lawyers advising them. The question is, are they willing to hear about it? Are they willing to adhere or even consider? The question is consider. So most of the time, they are the energy levels of PDCs are so high, they are so aggressive. It's very different from working with an MNC, which takes its own time in working. So it's a pleasure working with PDCs because of the energy level. But at the same time, there are areas where they are under compliant and they want to move forward with the business. I'm going to give you an example of a company which was in oil and steel and mining, which we were representing for a very long time. And there was a forensic report of coal pilferage, and there was a lot of pilferage of other raw materials. We were representing the other promoter, equal holder. The main promoter who was running the company, which was the managing director, was estranged with the promoter that we were representing. There were pilferage, there was siphoning off, there was foreign citizenships being taken, there was houses in London and Singapore being taken by the managing director and his cronies and his family. Everything was pointed out by KPMG in its forensic report. But nothing was adhered to. because of the primary reason that the independent directors as well as the nominee directors of the main promoter-driven nominees, they were all going in a quid pro quo with the main managing director because of the high compensation. That's where the remuneration and compensation and auditing part comes in. There was a lot of advisory committees. There were a lot of, KPMG forensic report, but nothing was done because independent director was compromised, the director itself, the board was compromised, and us as the minority promoter company, promoter as well, couldn't do much. So it's not always that they adhere to what they want. It's also what they want to hear. And the experience has not been good because if you do not listen to lawyers, you end up being wound up, which happened they got acquired by Tatas.
Very interesting anecdote. I'll go across to Alankrit. What advice have you given to promoters? How has it worked for them and your experience thereof?
So in the past year, I have advised promoters for probably, we have acquired roughly about 3,700 crores worth of land. And I feel when that kind of money is involved, lawyers are a very integral part. And you have to advise them about, you shouldn't just advise them about the legal part, but you should know what a promoter wants out of you. You should know the business about how he wants to do things and what his vision is. So after being a lawyer, you need to understand the vision about what your promoter wants and then advise them about the legal compliances, the things which you need to do, the things which you need to see while there are land acquisitions. And while you are selling at some point of time, you will build something on it and sell it to the customers. There are thousands and thousands of lives which will be associated with that particular piece of land. So you have to be very careful about the small things which you need to take care of in order to first achieve the growth of your business. And the second thing is the trust part when it comes to real estate. So we are a very important pillar in the advisory thing. And I think the time is changing. And promoters are listening to the lawyers, the financial advisors, and I believe that corporate governance will be the primary thing which India will see in the next decade as I speak right now.
Thank you for that comment. Interesting also. I'll go across to Vaibhav Kakkar from Saraf and Partners. You spoke about promoters. Well, what do you think the lawmaker is looking at, and also all this talk around promoter fraud, all of that?
Sure. Thanks, Tarun. Look, I often wonder, I must confess, how would it be like when you are sitting as a policymaker or as government and wondering about how to deal with it? And it's not an enviable place to be at all. There's one side of it, and we all know this on a day-to-day basis, that, a cop keeps telling you, don't park your car at a particular place, and nobody will listen to him. The moment he starts impounding the car, or the moment he starts issuing a huge challan, you'll see everybody following the line, right? So it's what the government has done is that I think they have gone with a gusto against delinquent and errant promoters. And if the messaging had to be given, I think the messaging is gone. And because, look, the number of instances and number of cases, Tarun, you have a regular update, the number of instances where ED, SFIO, EOW of various lawmaking, various judicial, various institutions of various states are active. It's almost difficult for us, even as practitioners, to keep a tab. So at one level, you have the finance minister on the floor of the parliament talking about decriminalization of offences under the Companies Act. In the same breath, you have more and more SFIO and ED and EOW cases getting registered against all business houses. So it is somewhat of a conundrum, and it's a paradox of sorts. I have two very important observations to make. One is, if you look at all of these cases that take place qua errant promoters, and you look at the conviction rate, you do realize, somebody somewhere out there is massively making a gross error at the time when they build the cases. The conviction rate is abysmally low. Somewhere the authorities have started believing that it's the process that's the punishment. So let us keep the delinquent promoter in jail while the process is being run. Eventually, whether the person gets convicted is not our lookout. That's the lookout of the court. And people who are errant promoters have started believing, if I have to stay in jail for a few months, I will. Eventually, I'll get bail. Conviction will happen and take its due course. So the guys who really need to be very worried are not too worried, because the ones who are determined to take everybody for a ride. But in that process, a lot of honest businessmen are bearing the brunt. And so my personal view is that you look at what has happened with IBC. Instead of having criminal liability and going with a gusto with all these investigation agencies, putting these guys behind bars for a few months, eventually getting bail, conviction rates. I mean, I'd love for some hardcore statistic, but I don't think, 95% of them ever get convicted. Instead of going down that path, I think what needs to happen is you go the path of economic sanctions. You impose heavy penalties. There is now, the Companies Act provides for class action suit. And I've just filed a class action suit for a shareholder client of mine. You'd be surprised to know, in this country at the moment, there are barely any class action suits that are out there. Even judges are not equipped to understand what kind of evidence they should look at when they're looking at class action suits. I think make the promoters pay if they're going delinquent. Instead of looking down the path of criminal investigations, make the promoters pay. Look at IBC, what it has done. With the dirty dozen, with the subsequent ones, I think promoters have largely understood, if you're leveraging too much, there can be a point in time where you can lose control of the business. And so similar mindset has to be there, that you will have to pay through your noses if you try and siphon money, if you handle public money, if you handle investor money irresponsibly. So that messaging needs to be clearly ingrained, and that can only happen if you make people pay heavily. So I think that's one mindset shift that needs to happen, Tarun. And very quickly, I think the other big point is that whenever there is a problem, I was involved in the whole Fortis saga and the whole revival of Fortis. I've also seen up close CG Power. What is very important is that whenever there's an issue of a delinquent promoter or promoters allegedly having conducted fraud, what is very important for the regulators and the policymakers is to believe and to clearly have that conviction that what they need to do first is save the business, save the company, save the stakeholders. What they did with Satyam, immediately ran an auction process, central government stepped in, ran an auction process, got in Tech Mahindra as the winner, got Satyam to be bought over. That mindset has to be there, where you have to force revival of companies, look at those businesses with a bit more consideration and compassion. That's what we saw with Fortis when IHH took over Fortis after the Singh brothers went kaput. So it's important. Similar thing with Murugappa Group when they took over CG Power. So I keep telling a lot of government and policymakers as well as investors, saying 9 out of 10 times, unless the company is in the infrastructure space, if you take the company into IBC, most of the times the story is over by then. So you have to talk about revival well before IBC kicks in, and their investor-driven sentiments and overall handling those businesses with soft gloves is most critical. So 2 points: make promoters pay where they're delinquent. Don't look at criminal liability. Rarely it leads to a conviction. And you can see with what's happened with reps and warranties. Once certain cases got decided against promoters on reps and warranties, and they all had to pay millions of dollars as arbitration damages, I can tell you in corporate negotiations, Seema and I will vouch for the fact, I think we spent days negotiating reps and warranties, because all promoters have understood reps pe achhe se negotiate karna hai. So, that mindset will change with this.
Thank you. Thank you so much for those interesting comments that you made as part of your closing comment. I'll go across to Pranav for his closing comment.
So while doing acquisitions, my major hello. Yeah. So while doing acquisition, my major role is not of an advisory but of an execution. So we do appoint law firms to do the advisory part, and for all these acquisitions, for instance, if there's a land conversion issue, obviously the law firm would be doing an advisory, but in the end, it's an in-house counsel who needs to make sure that in a practical time frame that land conversions is being done. And what from my experience I have seen is that the corporates wherein the corporate governance and compliances are more, they get more value, they get more multiple of EBITDA, and whereas the corporates wherein there is no corporate governance or less corporate governance, and the compliances are also not there, then obviously the valuation which we are giving to them would be reduced, and you will cut down the valuation, or maybe they'll have the deal would also not go through.
Thanks for that perspective. I'll go to Kanika Sachdeva. You want to make a point? No. Kanika Sachdeva from Stryker. Kanika, you work with a multinational. Very, very cautious whenever they take any decision. Their acquisition will not happen if due diligence is not proper. The balance sheet is not clean. They won't go ahead. In promoter-driven companies, what we see is, okay, acquire and then we'll think of what is the problem. Or as one very large promoter of this country told me, he took his manager to set up a plant. They said, sir, land acquire nahi ho. He says, plant banao, land acquire kar lenge. So, that kind of thinking of promoters. Your closing comment.
We are top of the hour, but I'll just quickly close that. See, transparency, accountability, and responsibility, in my view, are the three cornerstones, very important cornerstone of an effective corporate governance. So, say when you come to my perspective, ethical standing, sustainability are equal parameters which stand alongside, say, financial strength and market position of a particular company. And listed, of course, like, we talk about financial strength, etc. So the needle is moving in a different direction as well. And I think as and when, say, private equity players tend to come in, they also tend to get their own governance norms. So this is the kind of mindset that we tend to see in my space, right? Wherein we also have to make sure that we are talking about ESG, we are also talking about anti-corruption, we are talking about compliances with the FCPA, UKBA. Along with, of course, like, the requisite financial disclosures that need to be made, which need to be true, accurate, etc. We need to, like, make sure there is sufficient independence of the board. There is a decent balance between the board, like, executive, non-executive. We, tend to go over and above. So a lot of times people think, oh, it's a private space, maybe because there's not like over legislation when it comes to that. Corporate governance is just like a checkbox, right? But that's not the case. I think needle has started to move in a much healthier direction, even for, say, unlisted or private companies for that matter.
Thank you so much for the closing comment. This brings us to the end of the session. I thoroughly enjoyed this session. A lot of interesting perspectives from all the panelists. I earnestly request all of you to give a huge round of applause to each one of them. They made time to come on a Sunday and shared all these perspectives with us. Thank you, Seema, Kanika, Vaibhav, Alankrit, and Pranav for making time. And I have had an enjoyable time. Hope you too found this afternoon useful. Thank you so very much. Thank you.